and challenge ourselves to think differently about what it means to secure and sustain judicial independence across our dear continent. To our advisory board members, thank you for your steadfast and strategic guidance. To Afrobarometer Governing Board and Management, thank you for hosting and incubating the Africa Judicial Independence Fund. To our implementing partners and presenters, we are highly honored by your willingness to share your experiences with us and with one another today. Ladies and gentlemen, let me conclude by reminding all of us that judicial independence is not a luxury, neither it is an abstract principle. Rather, it is the bedrock on which development, democracy, and dignity stand. Without an independent judiciary, the administration of justice is compromised and the very fabric of our societies is threatened. Thank you all for being here today. Your dedication and commitment are truly appreciated. Together, we can make a difference. Together, we can ensure that the judiciaries in Africa remains a pillar of strength and integrity. Thank you. Okay, at this point, I will briefly introduce the facilitator for today's event. The facilitator is a Ghanaian renowned lawyer and also a senior lecturer at the University of Ghana School of Law. She has been instrumental in activism not only in Ghana, but across the sub-region. She was a member of, or the chairperson of the Constitutional Review Consultative Committee that was inaugurated in Ghana in 2023, whose work is now the basis for the current Constitutional Review Commission. She is no less a person than Madame Clara Behr-Cassati. Madame, you are welcome. Thank you.
Thank you. Thank you very much, Mr. Salahuddin. I think we can do better. I think given the background and all of that, we can do better for Mr. Salahuddin. As he noted, judicial independence is not a luxury, but the bedrock of stability of our society. And we are happy to be here. I don't think there's a better place to be anywhere than to be here on this topic and to have all of you present. And I'm already looking forward to the discussions that we're going to have, and then hopefully the contributions and hopefully reforms and recommendations that will come out of this to strengthen judicial independence and accountability on the continent. Now, with the welcome address done, I have the singular honor to introduce to you now the AJIF advisory board members, and then after that, I will also introduce the keynote speakers. I begin with Professor Willie Mutunga, who is the chairman of the board. Just briefly about Professor Willie Mutunga. He was Kenya's Chief Justice and President of the Supreme Court from 2011 to 2016. He served as Secretary General of the Commonwealth Special Envoy to Maldives in the second half of 2016. He was a distinguished scholar in residence at Fordham's Law Lerner Center for International Law and Justice School from October 2016 to May 2017. In October, the Honorable Professor Willie Mutunga was one of two foreign experts who advised the Constitution Review Commission of the Gambia on its draft constitution. Since October 2021, Justice Mutunga has been an adjunct professor in public law at Kabarak University School of Law. Also, Justice Mutunga studied law at Dar es Salaam University and Osgood Law School at the York University in Toronto. He played a pivotal role in the constitution-making processes in Kenya in the 70s and the early 90s. He worked on implementing Kenya's progressive 2010 constitution as head of the judiciary and president of the apex court in the country.
In his writings and judgments, he has advocated the development of indigenous, robust, patriotic, decolonized, de-imperialized, pro-people, democratic, and progressive jurisprudence that is not insular and does not pay unthinking deference to other jurisdictions, regardless of how prominent they may be. He has also advocated progressive jurisprudence for Africa and the global South as part of a significant contribution to the struggle for a just, peaceful, and equitable world. There is a lot that Professor Justice Mutunga has done that if I'm going to talk about all of it, I'll probably spend the rest of the day reading his contributions to the judicial history on the continent. But I like as well his vision, which he continues to pursue, which is that he has a vision of a planet, one that is just, free, peaceful, non-militaristic, non-sexist, non-racist, non-ethnic, gender just, non-eugenist, humane, ecologically safe, equitable, prosperous, and socialist. This is his vision for the planet. If Professor Mutunga is here, please can you give us a wave? He's online. Okay. Thank you very much. Next is also Professor Lauda, who is a member of the board. Professor Augustin Lauda is an accomplished individual with a diverse background. He graduated from institutions in Burkina Faso and France and has taught public law and political science at the university in Burkina Faso since 1995. Further, he has practiced law since 2016. Professor Lauda was a Fulbright visiting scholar in Boston University in the US and became a member of the American Political Science Association in 2000. He served as the founder and the first executive director, that is from 2000 to 2014, of the Center for Democratic Governance, CGD, a research center in Burkina Faso that focuses on governance and democratization, which in partnership with APSA organized a workshop on religion and politics in comparative perspectives in 2013 in Ouagadougou, Burkina Faso. In November 2014, Professor Lauda was appointed Minister of Civil Service, Labor and Social Protection in the transitional government of Burkina Faso. Since 2016, he has traveled frequently to New Caledonia, a French territory in the Pacific region, where he participated in the UN group of electoral experts and later led the group from 2018 to 2013. In Burkina Faso, Professor Lauda continues to teach at the university and manages his law firm. We can see the transdisciplinary expertise and experiences that he brings to bear on the board. If he's here online, is he online as well? Please give us a wave, yes. Thank you so much. Thank you so much for the work you do on the board. We also have Ayo Obi, who is a member of the board. Ayo Obi is a legal practitioner and partner with Olasupu Shonibari in the which is a Lagos-based law firm. The full name is Ogunsola Shonibari LP. She is a trustee of Senegal's Gore Institute and of the Brussels-based International Crisis Group. In Nigeria, she is on the board of the ZO Dibiazoe Memorial Libraries and is an active member of the Bring Back Our Girls campaign. Obi was president of the Civil Liberties Organization, Nigeria's first indigenous human rights organization from 1995 to 2003. And she has also been chair of the Transitional Monitoring Group of an election monitoring democracy building coalition of independent NGOs, the steering committee of the World Movement for Democracy and Nigerian Civil Society panel on police reform. She represented Nigerian human rights NGOs on the Police Council, on the Police Service Commission
from 2001 to 2006 and was a trustee of the Clean Foundation from 2001 to 2015. From 2006 to 2009, she headed the elections program of the National Democratic Institute's Nigeria office and also served on the steering committee of the Nigerian Governors Forum's state peer review mechanism. She has been a panelist at the Women's Forum in Deauville, France, the Oslo Forum, the Beijing Forum, the Chinua Achebe Colloquium in Providence, RI, among many others. Obi has written weekly columns on current affairs for Sunday Punch, Next, The Guardian, and delivered several lectures and papers on a range of human rights and democracy-related subjects. She presented You and the Constitution and On Point for the Nigerian Television Authority, and most recently, Ideas Radio, a program about integrity, ethics, and accountability in democracy on Nigeria. Please give it up for Obi. And Obi, thank you very much. Obi is online, right? Thank you very much, Obi, if you can hear me, for the work that you do on the board. We have as well Professor Henry Kwesi Prempeh, but I will be introducing him as keynote speaker, so I will not read his profile at this stage. I will read it when I am introducing him as keynote speaker. And Professor Kwesi Prempeh is a member of the board as well. Thank you very much, Professor Prempeh, for the work that you do on the board. Please give us a wave, and please let's acknowledge. Then finally, we have Kajal Ramjatan Koe. She's the director of the Africa program at the International Commission of Juries, ICJ. ICJ is an international non-governmental organization founded in 1952 with a mandate of defending human rights and the rule of law worldwide. One of the core pillars of the ICJ's work is to promote the independence of judges and lawyers. Kajal is a South African lawyer based in Johannesburg and has worked in the human rights sector for more than 20 years. She was the executive director of the Southern African Litigation Center from 2015 to 2020. At SALC, she led many strategic litigation cases focusing on various human rights issues, and in particular, judicial independence, rule of law, international criminal justice, freedom of expression and association. Prior to that, she was the program manager of the Refugee and Migrants' Rights Program at the Lawyers for Human Rights from 2002 to 2014. She has significant experience and expertise in the fields of asylum and refugee protection, migration, justice, and statelessness. She has also worked on international criminal justice, SOGI-SE rights, women's access to justice, and freedom of expression. Kajal has provided pro bono support on the boards of several NGOs for many, many years. Kajal is also online. Please let's acknowledge her, and thank you very much. So these are the members of the board, and as you can see from their profiles, we could not have been more blessed, as we would say in Ghana, for members steering the affairs of the board, and to them we say we are grateful. So please, let's give it up to them again. Okay, now next I introduce the keynote speakers. So at this point, I would now start with Professor H. Kwesi Prempeh. We hardly mentioned the name Henry. So when I saw it here and I had to mention it, it sounded different, seeing it here. Now, Professor Kwesi Prempeh is very well known, a renowned, distinguished legal scholar and governance expert. He currently serves as the executive director of the CDD Ghana. He has been involved with the center since its inception, and initially as a board member and later as its first director of legal policy and governance and co-auditor of its quarterly publication, Democracy Watch, from 2001 to 2003. Prior to his role at CDD Ghana, Professor Prempeh taught at Seton Hall University School of Law in New Jersey, USA. From 2003 to 2015, he achieved tenure as a full professor in 2008. Additionally, he served as visiting professor at Gimpa Law School from 2010 to 2011 and has been co-teaching Constitution Building in Africa, a course at the Central European University at Budapest, Hungary, since 2014. In 2013 to 2014, Professor Prempeh acted as a constitutional advisor to the UN Special Envoy to Yemen. He was a Reagan Fassel Democracy Fellow at the National Endowment for Democracy in Ghana and Africa. He has authored numerous publications, including articles in esteemed journals such as the Journal of Democracy and the International Journal of Constitutional Law. Kwesi Prempeh practiced law in Washington, D.C. He graduated from Yale Law School in 1993 and also holds a master's degree in business administration from Baylor University in Texas and a bachelor's degree from the University of Ghana. He currently serves as a member of the Ghana Law Reform Commission, and he's the chairperson of Ghana's Constitution Review Committee for 2025. The committee that His Excellency the President has committed, that its recommendations, all of them will be implemented. Ladies and gentlemen, let us give it up to Professor Kwesi Prempeh. Thank you. So I'll take you, give your speech first.
Okay.
The keynote and then. Okay. So will you?
Okay. All right. I can start. Thank you.
So,
Is this working? It's acting funny here, so I don't know. Okay. Good morning. Good morning and welcome to Accra. For those of you who are not from Accra, and to this morning's event. My principal here is Said, and he gave me the marching orders for this event. He asked that I give some perspectives on Ghana, but I will start somewhere else and maybe land in Ghana later on. But what I want to spend the next few minutes talking about is looking at the peculiar risks to judicial independence in a liberal multi-party democracy, and then use Ghana as a case. I think we tend to we take it for granted, basically, that authoritarian regimes are a mortal threat to judicial independence, while democracies are supposed to be safe places for judiciaries. And indeed, our experience here in Ghana under one-party states, under military regimes, attest to the exceptional threats that authoritarian regimes pose not only to judicial institutions, but sometimes to the lives of individual judges themselves. But my concern this morning is with the peculiar threats to judicial independence that come from a multi-party democracy. That regime type that is supposed to be safer, and it's presumed to be a safe haven oftentimes for a judiciary. So where exactly do these risks come from in a multi-party democracy? I will identify about 4 of those sources of risk, and then focus the balance of my remarks on the ways in which constitutional design in the Ghanaian context has exacerbated these risks. So from Alexander Hamilton's Federalist Papers, we learn that the judiciary is the weakest branch of government. And for Alexander Hamilton, what makes the judiciary the weakest of the three branches is that it has no purse, no sword. It cannot self-finance. It must depend on the political branches for financing and resourcing. And it must depend also on those branches, especially the executive, for the execution and implementation of its orders, because the judiciary does not have a police or an army. Now, this structural dependence of the judiciary on the political branches for operational effectiveness, not merely funds to operate, but also executives, for the executive to comply with as well as enforce court orders, does not disappear with democracy. In some respects, democracy complicates and amplifies the judiciary's structural dependence on the political branches. Politically motivated under-resourcing of the judiciary can readily and credibly, in a democracy, be blamed or framed as part of popular fiscal austerity measures and a need for democratic accountability to taxpayers. So when you are a democratically elected government, that gives you some leeway to put the squeeze on the judiciary in the name of saving the taxpayer some money. So that structural dependence that we identify with judiciaries sometimes gets amplified with a democracy. Relatedly, there is the point about the judiciary being the unelected branch of the three. The unelected branch problem is another source of the risk that judiciaries suffer in a democracy. Elected politicians claiming popular mandates can stand on their superior democratic legitimacy and support to challenge and undermine the authority of the courts, and in some cases mobilize popular opinion against the judiciary in a contest for power. The charge that the judiciary is seeking to undercut or undo the will of the people, so to speak, is a particularly powerful sword in the hands of a president elected to office on a widely popular or populist mandate. And I think contemporary examples of that abound, not least in Trump's America. Then there is the fact that you can't find in a judiciary something that you may not find in an autocracy or a dictatorship, which is partisan political polarization. In democratic settings characterized by strong, sharp, or political or ideological polarization between rival political parties or factions, the judiciary can often get caught in the middle, as each side of the partisan divide attempts to capture or co-opt the courts to do their bidding. In the process, the courts can get drawn into political and ideological fights between the contending parties and factions. This is especially likely when the courtroom becomes the battleground for settling all manner of political and partisan disagreements. And we find that, again, not just in the United States, but in many strong two-party democracies, including in Ghana, where many political battles are framed as legal challenges and fought out in the courtroom. There's the fourth source of risk comes from the jurisdiction of the courts themselves. Right? Oftentimes, dictatorships are able to avoid fights with the courts by simply ousting them of jurisdiction over a number of important issues. So in the experience of Ghana, for example, military regimes routinely took the power away from the courts to adjudicate certain matters. So they don't come to you, there is no conflict. Right? But judiciaries in liberal multi-party democracies often are granted wide and substantial jurisdiction over very important matters. And here is where they move from becoming, at least in the eyes of politicians, the weakest branch to sometimes the most dangerous branch in the perspective of politicians. And there are two particular sources of jurisdiction that get the courts embroiled in fights with the political class in a liberal democracy. The first is the power of the courts in modern contemporary constitutional democracies to interpret and enforce the Constitution. In cases where legislative or executive action is challenged as unconstitutional. So this gives the courts enormous power, one that politicians are often jealous of for the simple reason that it enables the courts to check the actions of the political branches. A second, and this is more common in the African context, is the power or the jurisdiction to adjudicate disputed elections. This has become a source of conflict between courts and politicians in many contemporary African democracies. It is important to note that before courts were drawn into this fray, election disputes in democracies, at least in the common law tradition, were heard and determined by Parliament. The switch happened in 1868 when it was proposed that the determination of election disputes be transferred from Westminster Parliament to the courts. And at the time, the Lord Chief Justice of England, Sir Alexander Cockburn, wrote this letter of protest to the Lord Chancellor. The confidence will speedily be destroyed if, after the heat and excitement of a contested election, a judge is to proceed to the scene of the recent conflict where men's passions are still roused. The decision of the judge given under such circumstances will too often fail to secure the respect which judicial decisions command on other occasions. Angry and excited partisans will not be unlikely to question the motives which have led to the judgment. The sentiments may be echoed by the press. So from the very beginning, judges have been quite worried about getting drafted into the political fight in the form of adjudicating election disputes. So these are, in my view, some of the peculiar risks that democracies throw up for judiciaries and for judicial independence. And I think that in the Ghanaian context, in my view, some of these risks have been exacerbated by the ways in which we have constructed our constitution, especially in respect of the judicial institution. Of course, the Ghanaian judiciary enjoys many of the standard personal protections afforded judges in democracies elsewhere. Fixed tenure, the Ghanaian judge on the Superior Court, if it's in the High Court, you retire at 65. On the Court of Appeal in the Supreme Court, you retire at 70. That's fixed tenure, not coterminous with the term of the president. So that's a security for the judge. They have guaranteed compensation, which is a charge on the consolidated fund. It may not be varied from budget year to budget year, and it cannot be varied at all to the disadvantage of the judge. That's also some economic security for the judge. And on top of that, judges retire on their salary. So these are standard protections that the Ghanaian judges have. The institutional independence of the judiciary as a whole is further safeguarded in at least two ways. So the Ghanaian judiciary has financial autonomy, in the sense that the Chief Justice, together with the Judicial Council, prepare the budget for the judiciary. The Minister of Finance or the President doesn't get to vary it to the disadvantage of the judiciary. They submit it to Parliament through the President, but the President may only make a recommendation or make a note. They cannot vary it. So it depends on basically the judiciary and the Parliament working on the budget. This gives, significant institutional protection for the Ghanaian judiciary. Then there's Article 2(4) of the Constitution of Ghana, which makes executive defiance or non-compliance with an order of the Supreme Court issued in a constitutional matter a high crime and a basis for impeachment of the president. So that is also, I think, a very big shot in the arm of the judiciary. So there are these unique features of the Ghanaian constitution that altogether, with the personal protections that judges have, I think help to promote judicial independence. Notwithstanding these, there are a few aspects of the constitution, in my view, that amplify the risk that judges face in on an everyday basis in a democracy. The first of it is that there is no cap on the number of judges who may be appointed to sit on the Supreme Court of Ghana, on the Court of Appeal of Ghana, or on the High Court of Ghana, right? And when you couple that with a fairly weak appointment process that I'll get to next, it opens up an invitation for court packing. So this is a real incentive for a president, especially one with a majority in the Parliament, to basically neutralize a court that they find is not to their liking, because there is no ceiling on how many judges you can have on the Ghana Supreme Court. And when I started to pay attention to matters of judicial independence sometime in the mid-90s, I think there were 10 or 11 justices of the Supreme Court. Currently, there are probably 20 or so. Remember that Ghana is much smaller in population, much smaller in the size of the economy, much smaller in landmass than Kenya. And Kenya's Supreme Court has only 7 judges, and that is a fixed number in the Constitution. We do not have a ceiling on any of the levels of the Superior Court, so High Court, Court of Appeal. And how does this work together with the appointment process? So for the Chief Justice, the President essentially gets to pick, nominates, and then there are some 2 bodies, Council of State and Judicial Council, that are supposed to play a part in the process. But unfortunately, the court's own case law has essentially rendered those 2 bodies ineffectual. It says, well, they're just there to be consulted, no binding advice. So the President pretty much picks, and the Parliament, by simple majority, approves. Now, that is even better, and that is for the other Supreme Court justices too. President picks, the Parliament approves. And that is not a particularly difficult thing for a president who commands a majority, as all of our presidents have commanded since 1993. So that's a fairly weak, the appointment process then allows you, taking advantage of this no cap, to really appoint onto the bench as many judges as you can if you feel that you have a hostile bench or that you want to neutralize the majority that you come to meet. Then the removal process on the back end is also fairly weak, right? In our system, it is triggered simply by a petition from anywhere, anybody, sends a petition to the president making certain allegations, linking them to the grounds stated in the Constitution, incompetence, stated misbehavior, those kinds of things. And the president then, together with a council of states, another body in the Constitution, dominated by the president's appointees, gets to make a prima facie determination of the matters, and that's it. And then, if the determination goes against or supports the allegation on the face of it, then the president proceeds to appoint, or the Council of State proceeds to appoint a 3-person tribunal, including sitting justices on the Supreme Court, who then sit in camera and go over the matter. This same process is the process that is used for other independent constitutional office holders, like the chair and members of the Electoral Commission, the Ombudsman, which we call the Commission on Human Rights and Administrative Justice, and Auditor General and the like. And in Ghana, this same provision has been used at least twice before to remove the ombudsperson and the Electoral Commission. So as a precedent, and currently as I speak, the current Chief Justice is suspended and it's undergoing removal proceedings on the basis of this provision. Then when you look at the presidential election petition adjudication in Ghana, it's also a bit fraught. There are no clear standards. We've had 2 election petitions, very divided court, and then there are really no clear standards in terms of what the standards for overturning an election is. It's a bit murky, and then the time limits, unlike Kenya, that usually has to resolve the dispute before the president-elect is sworn in. We resolve the dispute way after a president has been sworn in. And that, of course, changes the dynamics completely politically. The first time we did it, the court took 8 months after a president has been sworn into office to adjudicate a presidential election petition brought against the president-elect, who had already started working, appointed ambassadors, ministers. Even how exactly is the judiciary going to work freely in adjudicating election disputes under those circumstances? The last factor, I think, in our Constitution that exacerbates the risk to judicial independence comes from the powers of the Chief Justice. And I think here, we have moved from a conception of the Chief Justice as president of the Supreme Court, or primus inter pares on the court, to what I would consider an imperial Chief Justice, right? And from an innocent provision in the Constitution, making the Chief Justice the administrative head of the judiciary, has grown vast administrative power of the Chief Justice that in many respects, in my view, intrude upon the decisional independence of judges. So this practice in Ghana, which is supposedly rooted in the administrative power of the Chief Justice, to empanel the court. So if you have a 15-member court, a 20-member court, a 21-member Supreme Court, it is for our Chief Justice alone to pick which number of judges and which persons on the bench get to sit on any particular case that comes before the Supreme Court. That, of course, is a power that is liable to gross abuse, right? And there have been instances where courts that are already sitting, panels that have already been picked and sitting, are changed in the course of the proceeding, right? Giving rise to claims of, again, forum shopping and other practices on the part of a Chief Justice. So the unregulated nature of that power, of that empaneling power. Obviously, if you have too large a court, if you have a 20-member court, it becomes very almost inefficient for the entire court to sit. So empaneling more or less comes with the territory when you have a court as large as that. The Kenyan courts, 7 members can afford all to sit en banc and hear a case as a single court, as they do in constitutional, in many cases, and as they do in election petitions. Ours, well, our court is too large that it amplifies the power of the Chief Justice to empanel the court and almost justifies it. And to the extent that that power is unregulated, it does indeed compromise the decisional independence of the judges on the court. And this, because again, unlike Kenya, our Chief Justice is also a member of each of the layers of the Superior Court. Right? Our Chief Justice is a member of the Supreme Court. She presides over that. She's a member of the Court of Appeal and a member of the High Court. That's not the case in Kenya, where, based on their past experiences, the Chief Justice is only a member of the Supreme Court. Ours, historically, has been a member of all 3 layers of the court and has the same administrative powers on the Supreme Court as she does on those subordinate courts as she does on the Supreme Court. So there is a problem there. And I think that politicians, because of this enormous power of the Chief Justice, it has made that office an attractive office for capture by politicians. Right? So when you put together the everyday risk that a judiciary might encounter in a democracy, and then you lay this picture over it, you see that even in a country that is well celebrated as a liberal democracy as Ghana, we have done certain things with our constitution that I believe have exacerbated the risk to judicial independence, and some of it is playing out as we speak. So these are, for me, I mean, especially for the current work on the Constitution Reviews Commission, these are some of the challenges that we face in trying to address this issue of the independence of the judiciary. I would add one last point that I think is a bit self-inflicted, which is that, you know, given the nature of the challenges that courts face in a democracy, especially where you are faced with popularly elected executives, you know, with wide mandates, I think the courts have not also necessarily helped matters by the kind of freewheeling jurisprudence or approach to interpretation that I believe our courts have adopted. And I understand some of the history to that, but the Constitution, in a constitutional democracy, the Constitution is the supreme law of the land. It binds all branches of government. It binds the judiciary as well as the executive and the legislature. But when a judiciary, I think, takes the posture that it has no limits, I think that is likely to get it to run into difficulty with the political class. And I'm referring essentially to an approach to interpretation that is becoming almost standard in Ghana, where the courts sometimes completely disregard the text of the Constitution. Say, well, I mean, the law is in the bosom of the judge, and we can interpret these things, these matters, sometimes in ways that clearly go against the letter and oftentimes the spirit of the Constitution. So there's one case that I think, you know, exemplifies that. There is a provision in the Constitution, Article 296C of the Constitution that obligates administrative bodies to publish regulations to govern the exercise of their jurisdiction. It's administrative procedure that is not unusual. In South Africa, I think it's the Promotion of Administrative Justice Act that it's based on the Constitution. Now, there was a case involving one such administrative body or constitutional body exercising administrative function, And there was a requirement, a plaintiff, a suit, asking that this body comply with Article 296C and publish regulations to govern the exercise of its functions in a particular area. I think the case involved the demarcation of electoral boundaries by the Election Commission. And the claim was that this is a black box. We don't know what goes inside it. We don't know how you do it. Every now and then we get up and you've created 20 new constituencies, 2 new constituencies here, 3 there. How do you do it? Tell us. Tell us your methodology. Expose it. Make it transparent how you do this. And the Supreme Court says, well, they don't have to tell you. And that, Article 296C looks nice, but maybe if we were to enforce it to the letter, it would lead to a nuclear meltdown. But maybe it's just best practices, right? And I think when you do cases like that fly in the face of the letter, and in my view, as well as the spirit of a particular provision of the Constitution, then not just politicians, but academics and others look like you have no limits. I mean, the Constitution is whatever you want it to be, and that is not necessarily acceptable. So I think the failure to understand that judicial restraint and judicial acceptance of its own limits are part and parcel of what it is that defines a court whose jurisdiction is not inherent, but is granted in and by the Constitution. I think a failure to appreciate that there are limits, even to judicial decision-making, it exacerbates this risk because it then makes it look like, well, if you can do anything, if a court can do anything, then we might as well capture it. I mean, if you can really just look in the face of the Constitution and decide that we are not going to follow it, then it would be for the politicians also to want to do this. So I think these are some of the charges. The last one, I don't know how you resolve it through a constitution review process, because you still have to have the judiciary doing the interpretation. And in some countries, there are attempts are made in the Constitution to provide some benchmark by which judges must follow, must go by in trying to do interpretation or apply the Constitution, but I don't know how effective those are. So in my view, these are from my own, just some preliminary thoughts on what it is that makes judges vulnerable to interference in a constitutional democracy, and how some of these challenges may be made worse by the ways in which we design and write constitutions, and by some of the omissions and the commissions that we do in the process of writing the Constitution. Thank you. May I sit? Yeah.
Thank you very much, Professor Prempeh. I think we can do a lot better than that. Thank you. We are going to have a panel discussion after the keynote speakers. Okay, so we are going to have a panel discussion after the keynote speakers. So I would crave the indulgence of the keynote speakers to try and not go over 15 minutes so that we can keep with the schedule. Now, to introduce my next keynote speaker, Professor Alion Tyne. He holds a Doctor of Philosophy in Semiology, Communication, and Literary Texts. Professor, I think it's Tyne or Tyne. Forgive me if I got the name wrong. Professor Tyne has been an independent expert of the United Nations on the human rights situation in Mali since 2018. He is also the founder of the think tank Africa Jom Center. He was the president of the African Assembly for Human Rights, RADO, from 1998 to 2013. President of the Senegalese Human Rights Committee from 2013 to 2015, Regional Director of Amnesty International, West and Central Africa from 2015 to 2018, Coordinator of the activities of the African and Black Diaspora Organizations for the 2001 Durban World Conference Against Racism. This conference recognized slavery and the slave trade as a crime against humanity. He was RADO's electoral coordinator for the observation of the 1998 parliamentary elections, 2000 and 2007 presidential elections. Professor Tin, he was also professor at the Faculty of Human Science and Letters, University of Sheikh Anta Diop from 1981 to 2009. He was also professor of School of Journalism in CESTI from 1984 to 2005. He is writer and publisher of a lot of literary works and articles on politics and human rights. He has extensive experience in conflict mediation. He participated in the mediation process between the Senegalese government and the movement of the Democratic Forces of Casamance. Rado was quoted in 2005 Peace Accord thanks to his constructive role in mediation. He participated in the mediation process for the recognition of the 2000 presidential election results between Abdou Diouf and the opposition leader Abdoulaye Wade, which led to a peaceful change of government. In 2024, Professor Tin and the architect Pierre Koudiabe were among the mediators in the conflict between President Macky Sall and the leaders of the opposition, Ousmane Sonko and Bassirou Diomaye Faye. This led to the release of the political prisoners and the organization of the 2024 presidential election in Senegal. The government of Chad requested his mediation services in the wake of the 2022 bloody demonstrations. Professor Tin has contributed considerably to the resolution of conflicts in a lot of African states, including Burkina Faso, Niger, Mauritania, and Guinea-Conakry, among others. Ladies and gentlemen, please let's welcome Professor Tin as he gives us his keynote address. Thank you.
Bonjour, je voudrais saluer très chaleureusement toutes les personnes invitées et remercier chaleureusement Salahuddin qui m'a invité aujourd'hui et dire que je m'appelle Alioune Tine. Je suis d'abord activiste des droits de l'homme. Je vais parler d'abord des principaux défis et opportunités en matière de promotion de l'indépendance judiciaire en Afrique francophone. Une parfaite compréhension de ce qui se joue dans une société est cruciale pour la justice. C'est Amartya Sen que je cite. L'indépendance de la justice telle que nous la connaissons et pratiquons en Afrique francophone est d'abord un legs colonial. Pendant la colonisation, on avait dans les pays francophones une administration de commandement. Et à l'exception du Sénégal, où on a reconnu la citoyenneté française dans 4 communes, le reste des populations, c'était des sujets français. Donc à la merci de l'administration et également de l'arbitraire du commandement administration, de l'administration judiciaire, de l'administration coloniale plutôt. Ce qu'il faut remarquer aussi quand je parle des pays francophones et du Sénégal sur lequel je vais m'appuyer le plus souvent, c'est que c'est un pays qui a commencé à voter en 1848. Ça veut dire qu'il a commencé son processus, dirons, démocratique au 19e siècle, pratiquement au moment où, bien sûr, naissait la démocratie représentative au 19e siècle, avec la reconnaissance du suffrage universel en 1848. Mais ça, dans 4 communes seulement, ça veut dire Dakar, Rufisque, Gorée, Saint-Louis. Aujourd'hui, l'indépendance de la justice est menacée un peu partout dans le monde par des ingérences politiques, par un financement insuffisant, par des pressions médiatiques, mais également des pressions politiques et des pressions sociales. Concernant les pressions politiques, c'est-à-dire que nous vivons aujourd'hui une crise mondiale de la démocratie représentative, un peu partout dans le monde, et également l'émergence de ce qu'on peut appeler les régimes populistes en Occident. Et aujourd'hui, les régimes populistes rejettent le modèle libéral, ça veut dire la séparation des pouvoirs. C'est clairement dit par des théoriciens comme Chantal Mouffe. Et à la place, il faut effectivement respecter la volonté populaire, ça veut dire la souveraineté du peuple, la souveraineté collective. Et de plus en plus, les gens estiment que les juges qui ne sont pas élus, qui n'ont pas de légitimité, doivent être sous les ordres de ceux qui ont la légitimité. Et de plus en plus, on le voit dans des pays comme la Pologne, et on le voit aujourd'hui aussi aux États-Unis, on le voit en France, on le voit également dans les pays où nous connaissons les coups d'État militaires. Au Burkina Faso, où il y a un effondrement total de la justice, au Mali, où il y a un effondrement de la justice, au Niger, mais également en Guinée-Conakry. Donc, la crise de la démocratie a entraîné également une crise au niveau de la reconnaissance, de la séparation des pouvoirs. Et quand on regarde l'état des lieux, qu'est-ce qu'on constate? Quand on prend 36 pays, dans 36 pays de l'Afrique, d'après Afrobaromètre, ils croient beaucoup plus à la justice religieuse et à la justice coutumière qu'à la justice que nous avons héritée du colonialisme. Je pense que c'est extrêmement important, tout simplement à cause de la facilité de l'accès à la justice. La justice coutumière ou la justice religieuse est plus proche. Et la justice, avec ses mécanismes, fait peur de plus en plus aux populations. Donc, je pense que sur la question d'accès à la justice, nous avons beaucoup de problèmes que nous pouvons évoquer. Le fait, effectivement, que nous n'ayons pas assez de juges. Au Sénégal, nous avons 560 juges sur pratiquement 20 millions d'habitants. Le droit à la défense, parce que les avocats sont concentrés dans les villes, dans les capitales, à l'intérieur du pays. Vous n'avez pas d'avocat, ça veut dire que si vous n'êtes pas proche, vous n'êtes pas défendu. Ce qui explique d'ailleurs pourquoi les gens restent très longtemps en prison, parce qu'ils n'ont pas d'avocat pour les défendre. La confiance à la justice, il y a une grande érosion dans la confiance à la justice, parce que tout simplement, bon, beaucoup estiment qu'il y a beaucoup de corruption dans la justice. Ça également, ça fait partie des blocages dans l'indépendance de la justice. Maintenant, les principes fondateurs de l'indépendance de la justice. Bon, dans notre histoire, à nous les Africains, quand même, nous avons connu à travers la charte de ce qu'on appelle la charte de Kurukanfuga, date du XIIIe siècle, de Sundiata Keïta, la charte du Mandé, si vous voulez, un aperçu de ce qu'on peut appeler l'indépendance de la justice. Quand on affirme qu'une vie, c'est une vie. Ça, c'est le principe d'égalité de la justice. L'abolition de l'esclavage, c'était aussi dans la charte du Mandé, le respect des principes et des lois de l'Empire. Maintenant, la question de la séparation des pouvoirs. Juste après la colonisation dans les années 60 jusqu'en 90, dans le pays, c'était les partis uniques, c'était les dictatures militaires, le pluralisme n'existait pratiquement pas. C'est arrivé avec ce qu'on appelle les processus de démocratisation et de transition démocratique des années 90. Et dans ces années, nous sommes passés dans nos constitutions de ce qu'on appelle l'autorité judiciaire vers le pouvoir judiciaire. On a commencé à construire des cours constitutionnels dans des pays comme le Bénin, comme le Mali, comme le Niger. Mais quand on regarde à peu près la situation de ces cours constitutionnels, qu'est-ce qu'on constate aussi? Au Mali, quand il y a eu le coup d'État en 2020, il y a eu un effondrement du Conseil constitutionnel et c'était presque comme l'effondrement des institutions de l'État. C'est en ce moment que le coup d'État est intervenu. Et c'est après des élections aussi, les élections législatives. La question des liens entre l'exercice du pouvoir et la justice et la question des liens entre la conquête du pouvoir et la justice, c'est là où nous avons les pressions les plus sérieuses. Et nous l'avons constaté au Sénégal avec Sonko. Je pense que c'était la première fois où la justice au Sénégal a eu autant de pression quand Sonko a voulu conquérir la justice, être candidat à la présidence et empêcher. Ça veut dire que la justice, le pouvoir judiciaire, est une arme entre les mains de ceux qui ont le pouvoir pour invalider la candidature des adversaires. Au Sénégal, on l'a connu avec, comment il s'appelle encore, Khalifa Sall, avec Karim Wade, et avec le jeune Sonko que nous avons eu effectivement les blocages. Au départ, avec la violence et l'insurrection. Et à la fin aussi, avec une bataille juridique qui s'est déroulée pendant très longtemps. Et cette forme de résistance, au Sénégal, la résistance est valorisée. La résistance par rapport à l'oppression est valorisée. Et ça a permis de mobiliser les jeunes, ça a permis de mobiliser la société civile. Et ça a donné du courage à la justice. Parce que si la justice sent derrière une pression, sent derrière également une force populaire, ça marche. Et nous avons eu le courage de certains juges qui ont dit, mais écoutez, il faut remettre Sonko dans le jeu. Et c'est un juge de Ziguinchor, un juge de Dakar. Et à la fin, c'est un problème de diffamation qui a empêché à Sonko d'être candidat. Deuxième problème, c'est le report. Quelqu'un comme Macky Sall voulait faire un troisième mandat. Macky Sall, paradoxalement, il a gagné les élections en 2012 parce que Wade voulait faire un troisième mandat et on avait organisé une grande résistance avec ce qu'on appelle le M23. Pendant près de 8 mois, on a lutté contre le troisième mandat et c'est ça qui a permis à Macky Sall de gagner. Arrivé, il tire les leçons, il se dit, tiens, je vais essayer de faire plus que Wade, je vais faire le troisième mandat. mais c'était quand même joué sans la culture politique et la culture de résistance au Sénégal. Et pour le faire, il dit, bon, quand il a échoué, il a dit, bon, écoutez, maintenant, il faut que je reporte les élections et tout le monde va être candidat. C'est en ce moment qu'il nous a appelés avec Pierre Goudiaby Atepa pour nous dire qu'est-ce qu'on fait. Si vous ne sortez pas les détenus politiques, à cause des élections, on avait près de 2000 personnes qui étaient emprisonnées au Sénégal. C'est inédit ce qu'on a vécu là-bas. 2000 personnes étaient détenues. Plus le leader de l'opposition et celui qui deviendra plus tard président de la République. Et nous lui avons dit, mais si vous ne sortez pas les détenus politiques, si vous ne sortez pas les gens avec lesquels vous voulez négocier, mais il n'y aura pas la confiance. Et comment il faut faire? Et c'est là qu'il dit, mais écoutez, il faut que je pourrai, une fois qu'ils sont condamnés, faire la grâce présidentielle. Bien sûr, avec ce raisonnement, c'est le report. Le temps de juger. Il dit non, les Sénégalais ne l'accepteront pas. Et effectivement, les Sénégalais n'étaient pas prêts à accepter un report de l'élection présidentielle. Et les Sénégalais se sont mobilisés. Ça, cette expérience aussi est importante à souligner. Avec un mouvement qui s'appelle Art sur nos élections. Ça veut dire protéger notre élection. Pas question de reculer. Donc, c'est là où est intervenue la loi d'amnistie que nous avons proposée au président. Il n'y a que la loi d'amnistie qui peut nous sauver dans le contexte actuel. C'est comme ça que les détenus politiques sont sortis. Il a voté une loi pour le report des élections, malgré tout, et a aussi adopté un décret d'application. Et là, la tension était au sommet. Et l'opposition a saisi le Conseil constitutionnel. Et il y a eu la pression à la fois de la société civile, mais également la pression internationale. Parce que les sénateurs américains sont intervenus pour demander à ce que les élections aient lieu au bon moment, l'Union européenne, et puis il y avait également la mobilisation locale. Il me semble que tout cela a fait que le juge du Conseil constitutionnel a invalidé un décret du président. Et ça a été un moment de très grande fierté pour dire, écoutez, maintenant le Conseil constitutionnel, qui n'a même pas le statut des cours constitutionnels, parce que les compétences du Conseil constitutionnel sont très limitées au Sénégal, est arrivé à arrêter effectivement la volonté du président à reporter les élections. Je pense que c'est un moment très important à la fois pour le moral de la justice de façon globale, parce que nous allons revenir également sur ça. Donc les pressions politiques. Nous avons aussi les pressions religieuses. Chez nous, nous avons les confréries religieuses. S'ils ont un talibé que vous avez mis en prison, ils ont la possibilité de mettre la pression pour les libérer. Il y a également les pressions économiques, bien sûr. Pour ceux qui ont de l'argent et qui ont la capacité également de payer des avocats pour en sortir. La condition également essentielle pour l'existence de ce qu'on appelle l'état de droit, c'est l'indépendance de la justice et le respect des libertés fondamentales. C'est les deux. C'est-à-dire qu'aujourd'hui, c'est cette démocratie qu'on appelle une démocratie libérale qui est née au 19e siècle, qui est en crise, effectivement, qui a peut-être atteint ses limites, et qui fait effectivement que, bon, des populistes disent, voilà, l'alternative, c'est ça. Et là, également, ils se disent, mais il faut maintenant contrôler la justice. L'alternative, c'est ce qu'on appelle les démocraties souveraines. L'OADA est là. Je pense que ça, c'est le concept russe, démocratie souveraine, concept également aussi des Chinois. et qui de plus en plus séduit des régimes autoritaires, illibéraux en Afrique, et également donne des velléités pour toujours contrôler la justice et l'état de droit. Donc, garantit aussi des droits fondamentaux et des libertés fondamentales. Quand vous allez aujourd'hui en Afrique francophone, mais les libertés fondamentales, ça n'existe plus au Burkina Faso, où nous avons des disparitions de personnes, où nous avons des crimes à n'en plus finir. L'impunité est là. Si vous allez au Mali, c'est pareil. Vous allez au Niger, c'est pareil. Pire, on est en train de dissoudre les partis politiques. Et maintenant, ce sont des gens qui se réunissent pour dire, écoutez, bon voilà, M. Assimi Goïta, vous avez 5 ans et 5 ans de plus. Il n'y a pas d'élection, il n'y a rien. C'est ça aussi le règne de l'AOS. Des dictatures militaires totales où il n'y a aucune liberté. Mais il n'y a pas que les pays où il y a les conflits armés, parce que les conflits armés aussi, ça détruit les institutions de façon globale. La destruction des institutions, ça amène beaucoup de parasites. Vous allez au Mali, c'est pareil, vous avez le trafic de drogue, le trafic des êtres humains, toute forme de trafic, vous les avez aujourd'hui. Et ces trafics aussi, écoutez, c'est comme un peu le cancer. Hein. Une fois que ces frontières sont poreuses, c'est toute l'Afrique de l'Ouest qui est fragilisée par ces trafics et également ces destructeurs d'institutions. Donc le Mali, mais il n'y a pas que le Mali. Il y a la Guinée, la République de Guinée, où des leaders de la société civile disparaissent sans que la justice ne puisse se prononcer. Et de plus en plus aussi, ça veut dire que si vous n'avez pas de justice, si vous n'avez pas de médias, c'est le cas aussi, et si vous n'avez pas de société civile, parce que la société civile est en fuite, la plupart des leaders politiques, ils sont en exil, hein, en Guinée. Vous allez aujourd'hui en Côte d'Ivoire, et c'est ça le paradoxe. Hein. La Côte d'Ivoire reçoit les hommes politiques, les leaders de la société civile qui ne peuvent plus vivre dans leur pays. Mais en même temps aussi, en Côte d'Ivoire, on se sert de la justice pour éliminer des adversaires politiques. C'est ça qui est en train d'arriver aussi. Donc je pense que le sujet choisi est un sujet extrêmement important. Les problèmes, certains problèmes, le professeur Prempeh les a énoncés. Vous savez, la question de la dépendance de la justice par rapport à l'exécutif, c'est une dépendance structurelle. Prenons par exemple chez nous les procureurs. Les procureurs, ce sont les juges qui ont véritablement le pouvoir de vous mettre en prison ou de vous sortir de prison. Il est sous les ordres hiérarchiques du ministre de la Justice, qui lui-même est sous les ordres du président de la République. Donc, une des questions, c'est cette dépendance structurelle, la dépendance financière, le budget. Ce n'est pas le ministère de la Justice, ce n'est pas les juges qui décident de leur budget, comme l'a dit Prempeh. Là aussi, pour tenir les magistrats, c'est sur le plan financier. Donc, quand ils sont fragiles sur le plan financier, ils sont également vulnérables par rapport à des problèmes comme... Donc, maintenant, qu'est-ce qu'il faut faire rapidement? C'est tout simplement de réformer la justice de façon globale. Au Sénégal, on a tellement pris conscience de cela que 3 mois après son élection, la première des choses qui a été faite, c'est les assises de la justice. Il y a 1 an que c'est fait, avec pratiquement une trentaine de propositions, mais aucune décision n'a été prise en ce moment. Je pense que peut-être que d'ici quelques temps, ça va. Moderniser les infrastructures juridiques, y compris les prisons. Parce que aussi nous avons des politiques pénales héritées de la colonisation. Les prisons, c'est inhumain. chez nous, je ne sais pas, mais je pense que la plupart du temps en Afrique, n'ont aucun droit. Rien, ni hygiène, résorber le personnel, garantir l'éthique et la déontologie de la justice, garantir l'autonomie des organes en charge de gérer la carrière des juges. Le problème du Conseil supérieur de la magistrature, c'est un grand débat chez nous. Le président, il avait dit, moi, je ne siégerai pas dans le Conseil supérieur de la magistrature. Mais ce sont les magistrats au Sénégal qui disent, attention, monsieur le président, pour une garantie de sécurité pour les juges, nous préférons que le président soit. Et puis, j'ai eu le ministre de la Justice du Burkina Faso, parce que j'étais toujours dans le débat, qui me dit, Karim, qui me dit, Alioune, attendez, faites très attention, ne suivez pas l'exemple du Burkina, parce que la réforme du Burkina est allée loin. Je pense que c'est le président de la Cour suprême qui est président du Conseil supérieur de la magistrature. Il m'a dit, ça ne marche pas. C'est pour ça qu'il nous faut un débat beaucoup plus profond sur cette question. Et sur comment donner une légitimité qui permette effectivement aux juges de ne pas être sous les ordres des politiques. Les gens ont envisagé l'élection des juges comme aux États-Unis. Ce qui fait qu'effectivement, ils ont des vis-à-vis. Vous avez de la légitimité, nous avons de la légitimité. Ça, c'est une question qu'il faut poser. Et maintenant aussi, pour saluer, où est Salahuddin? Il est là? Voilà, je le salue. Je pense que c'est à travers des discussions et des débats de ce genre que nous pouvons approfondir les questions de l'indépendance de la justice et puis mobiliser plus. Il ne faut pas faire tout simplement dans une salle à l'hôtel, mais si nous avons des recommandations, je pense qu'il faut les partager le plus rapidement possible. Il faut que ça soit large et que ça soit une prise en charge personnelle des citoyens africains pour dire désormais, nous voulons protéger la justice pour nous, la justice qui est prononcée en notre nom. Nous sommes dedans. Ça veut dire que le citoyen qui est tout le temps exclu des institutions, comment est-ce qu'il faut faire pour que le citoyen revienne et prenne toute sa place dans les politiques publiques? Je vous remercie.
Okay, thank you very much. Please give another clap for, yes. Thank you so much for that. On his concluding note, the African people need to take control of their own affairs in these judicial matters. So next, what we are going to do now is a panel discussion. I have a few questions that I want to ask them. And then after I ask them the questions, the floor will also be open for questions. But we didn't start on time, so we are not doing too great on time. So the questions from me will try to be as brief as we can. And then after that, the floor will have an open session for the questions. Now, for my question, my first question goes to Professor Prempeh. And it is this. That given the entrenched executive influence highlighted in the AJIF's landscape scan, how can Ghana's constitutional review process serve as a model for insulating judicial appointments from political capture across the Anglophone country? From your speech, it was clear that the political class has a good reason to want to capture the judiciary. What do we do? Using the Ghana's constitutional review as a model?
Well, I think the very simple answer is we need to close the loopholes and the gaps. I think that basically because of the nature of the political transition that brought us this constitution, I mean, we've usually transitioned from military rule to democracy. And because of that, our concern at the point of transition has always been with democratizing the politics, right? Again, because military regimes have tended to oust the regular judiciary of certain jurisdiction and powers, when they are transitioning back to democracy, the judiciary is not one of the really main concerns. We tend to focus on multi-party, how we bring parties back into the game, how we reconstitute parliament and the executive. And the judiciary is usually not very much in the picture. That's the case of Ghana, right? Except in 1969, where I think the judiciary was also seen as having been one of the major victims of the one-party state under Nkrumah, and where there was a clear, very intentional, focused effort to rebuild the judiciary and build a brand new kind of judiciary with a constitution, with a Bill of Rights. I think our more recent transitions have neglected the judiciary, and therefore we haven't focused on the judiciary as part of the governance framework. So that's why, in my view, we have this constitution. The Kenyans, on the other hand, have basically lived under, a constitutional dispensation throughout, no military rule. So they've had an experience of how judges and the judiciary can be part of an autocratic system, can be part of an authoritarian regime, and therefore, when they got to the point of making a new constitution, it wasn't just about the politicians. The judiciary was very much a part of the reform project, and they focused on it, including bringing in international, including doing things that are unusual, letting the judges essentially reapply for their jobs and all of that. And I think that, of course, we are not at a point where our constitution doesn't allow us the freedom to remodel the judiciary. But I do think that the gaps that have been identified in the appointment process, certainly the practice of the Judicial Council in Ghana, it's not a Kenya-style Judicial Service Commission. It's a very weak council. When you look at the membership, it's clear it's not really going to be a big check either on the executive or even on the Chief Justice. So we do need to reconstitute those bodies. We need more parties to be involved in the nomination process so that it doesn't just become the president's pick and then it takes it to a compliant parliament and then they rubber stamp the appointment. So I think the appointment side is very important because of the polarized nature of our politics, almost America-style polarization. So we need to tighten up the appointment process. The removal process absolutely need to be tightened up. I think we glossed over it because when it was first used, it wasn't used against judges. But it's the same provision that's applied to judges. And we didn't pay attention to it when it was used against the ombudsman or the Shraj commissioner, and then subsequently when it was used against the EC. But now that it's being used against the Chief Justice, now we are like, well, but precedents have been set already. How do you change the rules when it comes to the Chief Justice? So we have to look at these two. But I also think there's a duty. I think there's a role for judicial accountability here, because sometimes the kinds of powers that our courts have exercised, including sometimes using contempt power to stifle even discussions of their decisions. I mean, they've become, what in some literature is called juristocracy. It's almost like we are a democracy, but we live under the thumb of judges who can make any decision. I think the judges must recognize that they too are subject to the Constitution. The Constitution is the supreme law of the land, not the judiciary, and that they need also to be mindful of the limits of their power, because if you are seen to be doing this freewheeling judicial review that is not bound even by any text, then others are likely to think that you are basically on a mission creep, on a power grab, and they are likely to push back. And not to say that judges shouldn't do their work, do the interpretation, do the enforcement, but there must be some standards, some rules about how you proceed. So I think our judicial review process, as you are aware, is a bit constrained. We can't change the whole Constitution. We have to work within the constraints that we have. But I do think there are enough opportunities in the Constitution. I've noticed that many of the provisions that are problematic are non-entrenched, even within the judiciary. Not the whole chapter is entrenched. So there are non-entrenched portions that we can amend easily through Parliament. The challenge is the one that have to go to the public in a referendum, and how you mix that with all of the other things that people want changed. That may present a challenge technically in terms of how you process it. But even if we're able to tighten the removal, the appointment, put a cap, which can be done, in my view, even by legislation. Many countries do it by legislation. Nigeria, many other countries have a judiciary act that stipulates a limit to the court, so you can change it. We have a residual clause in the Constitution that allows Parliament to fill certain voids in the Constitution. For some reason, people don't want to use that process. They want it to be done constitutionally. I think we will propose something along those lines. But the problem is already there. We already have over 20 justices on the Supreme Court. How do you bring the number down? What do you do with the size already? Because it's too many as we speak. And some solution has to be found to that problem. Not by removing them, but if you have to wait for attrition, maybe that's one way you do it. Because the larger the size of the court, the more the temptation is also to have a Chief Justice who continues to feel that the paneling power must be used to constitute the court. But even if it's to be used, we should regulate it. There has to be clear rules as to how you pick a judge to sit on a case, how you can and cannot remove a judge. I think we must restore confidence in that process of paneling so that people don't think that a Chief Justice is just playing games on the court with that power. Once the politicians see that the CJ has that power, they will go after the office. They will just go after the office.
Okay, self-preservation, I guess. Yeah. Okay, so my next question goes to Professor Tin. You've spoken about some of the things already, but if you can expand on, if we are looking at the context of Francophone Africa, where judicial hierarchies are often centralized, what do you think we can do to mitigate internal abuses of power and promote peer accountability within the judicial institutions?
On a eu des moments où le pouvoir judiciaire dans des pays comme le Niger ont tenté des choses qu'on ne pouvait même pas penser au Sénégal. Par exemple, en 2009, quand Mamadou Tandian, le président de la République, a voulu faire un troisième mandat, parce que c'était bien, on était dans un processus démocratique très fort et les gens étaient engagés, il y avait les meilleures institutions. D'abord, c'est le Parlement qui a dit à Tandian, vous ne pouvez pas faire un troisième mandat. Et ensuite, c'est la Cour constitutionnelle qui prend la décision pour dire, vous ne pouvez pas faire un troisième mandat. Une décision très sérieuse. Qu'a fait Tandian? Et c'est ça également où, des fois, le leader politique peut aller trop loin qu'on ne peut penser. Tandian a dissous le Parlement et il a dissous la Cour constitutionnelle. Ça veut dire que ça, c'est très fort. La Cour constitutionnelle du Niger, c'est mort comme ça, et après, il y a eu le coup d'État militaire. Ça revient. Nous avons eu aussi le Bénin. La Cour constitutionnelle du Bénin a empêché à Kérékou de faire un troisième mandat. Une décision extrêmement courageuse. Et puis le successeur aussi. Le grand problème, c'est l'addiction du pouvoir dans les pays francophones. Vous y arrivez avec vos amis. Et puis, bon, le mot pouvoir pour nous, en Wolof, pouvoir, ça veut dire jouissance. Si vous travaillez le mot pouvoir, ça signifie jouissance. Je ne sais pas quel est le mot dans d'autres langues. C'est pour jouir. Et il me semble que c'est ça qu'il faut changer. Une fois que Senghor avait dit que le pouvoir était un poison. C'est pour ça qu'il a quitté. Mais il a quitté aussi parce qu'il y avait une pression très forte, une résistance très forte qui a poussé Senghor dehors. Maintenant, la solution, c'est la mobilisation des corps intermédiaires. C'est-à-dire qu'il faut qu'il y ait une bonne société civile. Il faut que les avocats, les barreaux, se mobilisent. C'est extrêmement important. Chez nous, il y a une tradition du barreau depuis Lamine Gueye à défendre effectivement les gens qui étaient brimés, et les chefs d'État, les rois qui étaient brimés pendant la colonisation, à Madagascar, en Algérie. C'était l'avocat Lamine Gueye, c'est un avocat sénégalais. Et les autres avocats ont pris cette tradition. Dès qu'il y a un opposant qui est empêché, nous avons un groupe d'avocats qui est là, nous avons la société civile qui est là, nous avons les médias, nous avons les réseaux sociaux aujourd'hui. Et sérieusement, ça opère. Au moment où je vous parle, il y a un grand débat parce que le Premier ministre Sonko, donc il a fait un rabat d'arrêt. Les troupes, il est puissant, Sonko, à l'heure actuelle au Sénégal. Le Premier ministre puissant. La Cour suprême a pris une décision pour invalider Sonko. Sonko a fait un discours où pratiquement il s'est plaint sur Facebook. Et les magistrats sont fâchés. Aujourd'hui, on sent la résistance du conseil, comme on dit, de l'Union des magistrats du Sénégal. C'est un peu le syndicat des magistrats. Donc, si nous avons ces corps, les magistrats, les avocats, la société civile, les médias, les citoyens, il me semble que c'est une solution. Nous aurons un groupe de pression pour dire nous voulons une justice égale pour tous. Et nous voulons effectivement que les gouvernants rendent compte. Et c'est ça l'état de droit. L'état de droit, c'est l'état qui se soumet au droit. Et aujourd'hui, ce n'est pas en Afrique francophone où les gens remettent en question l'état de droit. Parce que nous avons de grands universitaires qui disent le droit contre la démocratie. Et qui font des conférences sur le droit contre la démocratie. Tout ça pour voir comment encore assujettir la justice. Et de mon point de vue, on n'est pas sorti de l'auberge. Le problème devient presque un problème mondial, le problème d'une espèce de régression globale de la démocratie dans le monde. Et en Afrique, vraiment, ça a des formes, les pires formes que nous avons. Ça veut dire la montée des autoritarismes, des populismes et des dictatures militaires.
Okay, thank you very much for that. Now, just building on your last point with respect to civil society. So my next question will go to Professor Prempeh. You lead a civil society organization that has been in the trenches for decades. Now, my next question is going to encompass 3 strands. One strand is to build up on what you think civil society and the legal fraternity, how they can be empowered to hold governments accountable. Professor Ten just touched on that. I also want, you already also talked about the Kenyan experience with respect to appointments of judges and all of that. I also want you to look at the South African experience. If you have suggestions or recommendations on how we can adapt or what lessons can also be learned from the South African and the Nigerian experience. And then finally, also you talked about the issue about the Chief Justice, the power as an administrative head that the Chief Justice has. There have been in several jurisdictions in Africa, there have been concerns that sometimes the Chief Justice either issues internal threats or political messages to judges, which then would affect those judges' independent view of the process as well, their judgment. So just tie it in with that, more suggestions as to what you think we can do to address all of those three strands?
Yeah, I mean, I think, to take the last one first, I think we have to, the role of the Chief Justice and administrative head, in my view, it looks, for me, it's really more like, yes, she sits at the head of the institution, working together with a judicial council, managing the judiciary. But I think her first role, in my view, the Chief Justice's first role must be as a jurist and the president of the court. The way I see the administrative head, it's more like a chairman of the board kind of a role. There's a judicial secretary who is like the chief registrar, and I think that we should probably be clear about the division of labor between the two, so that the chief registrar or the judicial secretary will do most of the administrative things. Unfortunately, in our, not just judicial culture, our culture generally, when you say somebody is the head of something, they basically aggregate all of the powers. They even allocate things like bungalows where you have to stay, who travels to a conference, who even speaks at an event. I've had the occasion at CDD at some point inviting a justice of the court to participate in a forum. And the justice told me that he doesn't have the permission of the Chief Justice to come. That is how much power a Chief Justice has, even over her own peers. I mean, how is a justice not to be able to participate in an academic civil society conversation because his or her boss would not allow him to do that, or that he doesn't have the permission? Maybe she's traveled or something. So I think that we need to be clear about the boundaries, the division of labor between the chief registrar or the judicial secretary and the Chief Justice as head of the judiciary. And where the head of the judiciary function interferes directly in adjudication, then I think that we have to have very clear rules, right? If you must empanel, there must be a process by which that is done. The whole court must agree, maybe the Supreme Court as a conference must have a certain process by which judges are picked, a rotation, some way so that it is not seen as forum shopping. If we continue to allow the Chief Justice to exercise this kind of power, this magnitude of power, solely at his or her discretion, I think that we are going to have these kinds of attempts to co-opt that office by anybody who has political power. So I think it's a very crucial thing. We really need to regulate this problem so we don't have, because once you have a Chief Justice who has this power and you can make that person compliant, then you don't need to make a phone call to any other judge. As president, you just have to basically talk to one person and the message gets through the system. The president wants the decision go to this way. In other places, the president will probably have to call the judge sitting on the case and say, or the AG would have to call and say, you better not rule this way. But here, you just have to talk to the CJ, and possibly, if he or she has that power, you can get your way. So I think there is a problem. Even if it's just perception, we should cure it. It's not good. And on the other side, I think that the court must also be willing to accept that judicial independence must come with judicial accountability. Because they are not elected, they must be more open to scrutiny by at least their peers. The legal academics, law journal articles, these are the only ways that many legal cultures hold judges accountable. But I am aware of instances where at an academic event, a legal scholar who has done some research on the judiciary was warned publicly by the judges who were there that this kind of scholarship undermines the judiciary and that, it almost is like contempt. How? Right? This is legal scholarship. This is academic freedom. You are invited, the person is scrutinizing decisions of the court based on who appointed who and trying to do some empirical work to see if it influences the outcomes of cases. And then the judges, are up in arms against this person for doing that. If academics cannot criticize you, if lawyers cannot the bar cannot criticize you. And if you're going to use contempt power to stifle debate, then how are we to hold you accountable when you are not elected? And so I think judges must accept with some humility that the power does come with responsibility, that there are in fact limits to the power, and that they must be open to peer accountability of the kind that we've just discussed here. And I think finally on civil society, clearly civil society does have an important role. Judges must know that we are their allies. Basically, when you are in trouble, it's to civil society that you are going to run. And so creating, these kinds of an adversarial relationship between the judiciary and civil society is not at all helpful, because again, you don't have an electoral base for support. It's civil society that you have to really court, because in these difficult times, that's where you are going to need your support. At CDD, we had a program, we inaugurated a project called Judicial Review. The idea was to have regular discussions of judicial decisions that impact governance, positively or negatively. I think Justice, who is here from Cape Town, was at the very first program we held. It was a hybrid event, online, other things. It was to review the decision of the court in the election petition 2020. Among the participants, it was a diverse group of participants, including the current Attorney General, who was then former Attorney General, deputy at the time. And after the show, after the program or show, he got summoned before the General Legal Counsel for suggesting that the court had not been impartial. Again, this is a civil society program. We are discussing the decisions of the court. We are reviewing it, to see ways we could improve it. And that was our contribution. We think, judges' decisions are important. They affect governance in many different ways. And so we were going to start this judicial review program so that we would offer judges, academics, civil society an opportunity to keep up with what the courts are doing. We thought it was a good contribution. But because of the action that was taken against that particular member of the panel the first time we held the program, we quit. We didn't do the program again. We shut it down. Right? So I think it's important. I really think that we need to get the courts to come to some understanding that the fact that you have the last word on what the Constitution means does not mean that there are no limits to your power. The fact that you have contempt power does not mean you must use it extrajudicially to shut down conversations about the courts. Because if you start putting yourself in that role and you become like a tin god, eventually, when you are in trouble, you will not find allies. So for me, that really worries me, that the judiciary must understand that the power it holds is awesome. It is the envy of the political class. They want that power. And if you don't build relationships in civil society, with the bar, with legal academy, with all of these, how exactly are you going to defend yourself against these kinds of attacks that are going to come inevitably? Right? So based on my own experience, I think there are lessons in what we're going through for the judges and the judiciary generally, and that civil society definitely must go to the aid of a judiciary that's under attack, but the courts themselves must make themselves friendly to these kinds of third parties. Sure, I think we can. There's a lot we can learn. I mentioned Kenya, but it's also informed by their historical experience, because the apartheid judiciary was very much a part and parcel of the apartheid project. I mean, when they had a new constitution, which they thought was more progressive and liberal, they just couldn't trust that you would hand over this brand new progressive constitution to the same old court system. So they created another layer of court, a constitutional court. maybe we can look at that as an addition to our court structure. Our Supreme Court has both constitutional and general jurisdiction, appellate on everything. But sometimes I also think the way we choose our courts, our judges to the Supreme Court, we tend to promote or elevate them from the court below. And yet the Supreme Court has original jurisdiction in constitutional cases. So if somebody has spent all of their career in the court, in the Superior Court, from High Court, and they are not doing constitutional law because they don't have jurisdiction. Only the Supreme Court has original jurisdiction. And they've spent a career, 20, 30 years, and they are the only ones you are going to promote, then you have to accept that by the time they get to the Supreme Court, maybe their constitutional law is rusty, right? I mean, they've not done constitutional law as a career, for 30 or so years, right? So I think we must also diversify, basically the sources from which we pick judges. Legal academics, especially if we are going to have the same system where the Supreme Court is the first place you go with a constitutional case, then we need to really widen the scope and bring in diverse perspectives, not necessarily elevate most or all of the judges from below. So that's one thing I think we can borrow from the Supreme Court. The judges also complain that the caseload is too large. And maybe, we have to find ways of not getting, and that is also part of judicial trust. Public trust in the judiciary is very low in Ghana. And part of the reason is that the process of adjudicating cases is so slow. There are so many cases. People are bogged down in the court for decades, sometimes decades, land matters, business matters, sometimes for years. And that destroys faith in the institution. So if there is a caseload problem and the Supreme Court is doing too much, doing all the appellate cases have to terminate there, all the constitutional cases have to originate there, then we must look at that again and maybe parcel out the jurisdiction in such a way that some things terminate at the Court of Appeal, or that we distribute the constitutional caseload down so that other judges get to commence those cases and they only come to the Supreme Court on appeal, so that we don't have this public trust issue with cases just sitting there forever and not getting resolved. Meanwhile, parties are dying, they are losing the value of their assets, land is stuck in litigation for years, it's not productive. Businesses, are shut down because the case is being liquidated, wills and, inheritance cases. The public just needs a court that is more responsive and that works, so that they don't take their cases, the law into their own hands and all of that. And I think lastly, while we tend to speak more about the administration of justice in the superior courts, as we call them in the common law system, High Court, Court of Appeal, Supreme Court, the average Ghanaian experience of justice is not in those courts. It is in what we used to call inferior courts, which we now call, how do we call them now? The lower courts. The average Ghanaian's experience of justice is in the magistrate courts, the district courts, and the circuit courts. And yet, that is not usually part of our conversation. Even when we're talking about constitutional review, most of the submissions, most are about the elite courts, High Court, Court of Appeal, Supreme Court. What about where 80% of the people get raw justice, very raw justice in some cases? So we must also focus attention on what goes on in these lower courts, which is not usually reported by the courts, and yet where most citizens will get railroaded, oftentimes literally railroaded, because nobody is paying attention to what the judge is doing. The judge and the police, sometimes you can't even tell the difference. There's a lot of injustice that is perpetrated in those courts, but they don't get the attention that the other courts get. So I think we should also rethink our focus when we talk about judicial independence. It's also those courts. Are those courts independent? Who chooses those judges? It's pretty much the Chief Justice and a few people. The process is not even transparent at all. If you think that the other court systems are bad, look at that court. We don't even know how they get chosen. So again, I think we should focus attention so that the people, this is the public generally, not just the elite, know that the judiciary exists to serve them. as in fact our Constitution says it's its mission.
Thank you very, very much. Now, my next question and final question as well goes to Professor Tin, and it will also straddle three aspects. You talked about the trust in the traditional informal justice systems in some of our African countries. I would like you to look at it, and you noted that they remain dominant in countries like Mali. Now, with how can we reconcile these traditional informal justice systems with the formal judicial reforms for more effectiveness and then for more access to justice in a way that people can trust? And I also want you to look at the role of the regional bodies. Yes, we have Francophone, we have Anglophone, we talk about our differences, but I'm sure also when you go into the communities, you can see a lot of similarities between all the African countries. So I also want you to look at how through ECOWAS and then through YAMU, we can help to reinforce protections for charges. And then finally, how we can ensure that the judiciary operates independently from political and executive interference in countries like Senegal and Mali. Thank you.
Merci beaucoup. Bon, la justice traditionnelle est plus facilement accessible, beaucoup plus proche. Et plus proche aussi parce que elle parle la langue des justiciables. Tout cela, ça compte. Par exemple, maintenant, dans le formel et l'informel, sur des questions comme le mariage, il y a une collaboration entre la justice traditionnelle et la justice formelle. Généralement, quand vous allez à la mosquée, vous faites par exemple le mariage, ce papier de mariage signé par l'imam, ça peut effectivement, ça fonctionne aussi auprès de la justice. C'est une pièce justificative reconnaissant que vous êtes marié. Je pense que dans le cadre aussi de l'héritage, c'est là où il y a le plus de problèmes. Dans le cadre de l'héritage, généralement, la justice religieuse fonctionne mieux que la justice formelle qui est très lourde, qui est très lente. Et puis maintenant, moi j'ai été au Mali pendant 5 ans comme expert indépendant et on m'a dit que dans les villages contrôlés par les djihadistes, la justice fonctionne mieux. Quand vous avez des problèmes d'animaux, de vaches, ça se règle plus rapidement. Alors que, bon, il faut le dire, dans le cadre du conflit, des conflits armés aussi, la justice ne fonctionne pas comme il faut. Ça, c'est un grand problème au niveau du... Donc, je pense que dans le cadre des débats que vous organisez, Salahoudine, évitez à la fois les juges traditionnels, les juges coutumiers et les autres juges. Et il me semble que de ce débat peut peut-être naître quelque chose, une espèce de synthèse, qui va être une synthèse africaine entre effectivement ce que nous avons hérité des colons et bon, ce que nous avons hérité ailleurs. Hein, je pense que la justice religieuse comme les cadis chez nous, nous l'avons hérité aussi des Arabes. Hein. Ce n'est pas une justice proprement africaine. Mais il y a la justice coutumière aussi qui se fait. Hein, quand vous regardez les films de Nollywood, généralement, vous voyez que la justice traditionnelle aussi fonctionne. Maintenant, les cours de justice, comme on dit, communautaires, comme la cour de justice de la CEDEAO, ça joue un rôle fondamental. C'est comme, si vous voulez, comme on dit, le dernier recours. C'est le dernier recours des citoyens de la CEDEAO. C'est une bonne cour, parce que quand même, c'est la compétition qui fait sur la base de la compétition que recrutent les juges. Donc, ils sont bien formés, ils ont une bonne compétence. Et ils sont aussi indépendants. Moi, j'ai créé une jurisprudence en 2012. Après les élections, moi, j'ai été agressé, gravement agressé au Sénégal, avec beaucoup de gens qui étaient, si vous voulez, il y a des gens qui ont été tués, massacrés. Quand on est parti, le gouvernement du Sénégal, à l'époque, a envoyé un juge pour le représenter et qui a dit, nous sommes des organisations de la société civile, nous ne pouvons pas, nous n'avons pas compétence pour saisir la justice. Et puis il y a eu, comme on dit, ils ont comme on dit, suspendu, ils ont réfléchi, ils sont revenus. Moi, j'ai donné des détails, j'ai dit, bon, écoutez, j'étais quand même le président de la RADO à l'époque, président d'une organisation de droits de l'homme. Eux, ils ont estimé que c'est une cour des droits de l'homme, qu'on était compétent. C'est comme ça que la société civile peut saisir, les citoyens peuvent saisir, et souvent, il y a des décisions qui ont été favorables à des candidats qui avaient été invalidés, comme Khalifa Sall a eu raison auprès de la justice de la CEDEAO, Karim Wade a eu raison auprès de la justice de la CEDEAO. Malheureusement, il n'y a pas de mécanisme pour le respect de cette justice. Les gens respectent, comme on dit, préfèrent la souveraineté nationale. Sur la question de la justice et sur la question des conflits, la faiblesse de la CEDEAO, c'est en réalité la préférence nationale. Ça, c'est un problème. Mais tout de même, sur la question de l'esclavage, je pense que c'est la première décision qui a été prise, c'était au Niger, une jeune esclave. Et donc, c'est une cour très progressiste de mon point de vue. Mais attention, on est en train de l'affaiblir avec des décisions qui risquent de diminuer le nombre de juges. Ils étaient 11, je pense qu'ils vont aller vers 5 juges pour quand même les pays de la CEDEAO, c'est un problème. Il y a également les Nations Unies. La plupart des gens, aujourd'hui, nous avons par exemple la Haute Cour de justice qui juge les ministres au Sénégal. Mais la Haute Cour de justice, disons, depuis 1963, quand ils ont jugé le Mamadou Dia, qui a été le premier président du Conseil au Sénégal contre Senghor, c'est une justice où la majorité des juges sont des parlementaires. Et la majorité des juges appartiennent au parti, comment dirais-je, au parti au pouvoir. Résultat, à l'époque déjà, le procureur sénégalais qui était quand même, pendant cette période, a dénoncé cette justice comme une justice qui est spéciale. Badinter aussi, qui était avocat de Mamadou Dia. Mais aujourd'hui, on remet la justice, la Haute Cour de justice. Ils vont saisir la CEDEAO qui va donner raison, parce qu'il n'y a pas d'appel. Une fois que vous êtes condamné par cette justice, dominée par des députés du parti au pouvoir, il n'y a pas d'appel. Il n'y a pas de recours. Donc, ils vont être condamnés par la Cour de justice de la CEDEAO et ils vont être condamnés également par les Nations Unies, comme ce qui s'est passé en 2012 avec Karim Wade. Voilà. Mais maintenant, si vous avez une satisfaction politique, une satisfaction morale, mais dans les faits, vraiment, ces décisions ne sont pas appliquées. Et c'est là où il y a le problème. Et c'est là peut-être où on devrait agir en tant que société civile, en tant que magistrat, en tant que citoyen, pour faire en sorte que les décisions de justice, comment dirais-je, de la CEDEAO soient appliquées. Comment trouver des mécanismes pour que les décisions de justice de la CEDEAO puissent être appliquées. Il me semble que ça fait partie des problèmes de la CEDEAO à l'heure actuelle.
Merci beaucoup. Thank you so much. So now we are going to have questions. So what we'll do is I'll take 3 at a time. So let's see. Please, any questions from you? We'll take 3 at a time, and then we'll have a response, and we'll take the next 3. Yes. Can I have assistance with the mic?
Thank you.
Thank you.
I'd like to take it with a grain of salt that some of us who are not judges or lawyers are usually terrified of asking questions from the likes of you. So I have to say that, listening to the professor from Senegal, a thought came into my mind that it seems that the Senegalese experience shows that by, standing up on your feet in the street, it has really impacted particular legal policies for the country. So it triggered for me as well the discussions that you have concerning judicial reviews, whether today or I've heard them elsewhere, is have other models been looked at. I'm speaking specifically now with say, for example, the Swiss model, which is a direct democracy. It's seen as probably the most successful democracy. Of course, take it with a caveat that it is a very small-sized nation. However, there's a system in place that I think they go through maybe 100 referendums, maybe nationally a month or so, and they do direct voting that is at the local, regional, and federal levels, depending, of course, on the topics. And I ask this because sometimes from the experiences that I have come across in my life is that in Africa we tend to do these judicial reviews that stay within the system that has been ordained upon us, let's say, from post-colonial times. So to what extent is there an appetite for academic scholarship as well as the sort of judges on the ground to be looking at something that can be transformative? I'm speaking now intellectually as less so how much it would cost infrastructure-wise to do that, but that's my first question. So it's really the appetite that you have seen through academic scholarship. And 2, a more, I think, a totally different question is if you could say something about the social justice mechanisms. These are critical today in Africa, as you know, in crisis countries. It's becoming part of the obstacle for conflict resolution, the fear of retribution as part of a conflicting situation. As you know, guerrillas don't want to come to the table, they don't want to be punished. Here, my question is, what do you think, from your experience, would be the perfect role for judges in a situation like this? Thank you.
Thank you very much. Thank you very much. Our next question. Oh, please, I'm sure you, quite a number of you must have questions to ask. Yes. Thank you.
Thank you. I'm Jonathan Asari. Ordinarily, I wouldn't have asked this question, but it appears there's a lull, and I want to fill that lull. Respectfully, I'm a Ghanaian lawyer, and I'm following issues concerning the removal of the Chief Justice. In a never-seen situation where the Chief Justice is undergoing removal processes and proceedings on the basis of petitions and responses which the public has had the view of. And indeed, Africa Judicial Independence Fund has made a statement about the removal process. It's safe to hold itself from commenting on the petitions which I know they've had the benefit of. Respectfully, what should be the way forward, given that the removal processes as constitutionally provided, and as indicated in the address of Mr. Prempeh, Professor Prempeh, what should be done in terms of, should the removal process be removed from the president and given to an independent body? So that's the first question. The removal process, should the president be removed out of the whole process? Because making the president the determiner of a prima facie determination means the president, as we saw in the case of Akabuafo, where there was a petition against him and the petition was dismissed based on the fact that he exercised judicial discretion, and that a judge cannot be held responsible for. But in the case of the Chief Justice, we saw the opposite. So should the president be removed from the entire process? Additionally, secondly, that's the first question. And the second question is, and I'm sorry, it's double-edged. The Chief Justice has come out to make complaints, which I've never seen in my life, of a Chief Justice addressing the press on issues of the removal, of her removal, which, again, in and of itself is historic. It never seen before, never happened before in my life. Never thought I would see a day where a petition, which indeed is grounds for misconduct of a lawyer, being the basis for the hearing of the removal of Chief Justice. The Chief Justice does make complaints about the body set up under law to interrogate petitions brought against her. And these concerns really were attempted, the Chief Justice attempted to bring this to the attention of the Supreme Court. And the Supreme Court relied on the in-camera edict of the Constitution.
The benediction must not be longer than the mass.
I apologize. The Supreme Court said, to cut it short, the Supreme Court said that what happens in the proceedings cannot be brought in the forum of the court for the court to adjudicate on same. Respectfully. My issue is, one, what will be your comment on the presser of the Chief Justice raising concerns? And two, should that bar in terms of in-camera, should we have a relook at in-camera? So again, from guidance of Madam Kasati, my first question is, should the president be removed from the proceedings for removal of the Chief Justice, which applies to constitutional bodies? Two, should what is your comment on the presser of the Chief Justice in terms of irregularities and things she finds to be illegal at the committee? And three, should we relook at in-camera provision under Article 146 of the 1992 Constitution? I apologize, I'm grateful at the same time.
Yeah, that's fine.
Thank you very, very much for that. Okay, let's have a third question, even though now I think the questions I have are like 5. But let's take the third one, and then we come back to our panelists.
Thank you very much, and thank you to the panelists. I enjoyed the conversation. So, as a follow-up to my friend there, I am personally a victim of the removal process in my country. As the former Auditor General of Sierra Leone, with all the laws, as you have mentioned here, the protection under the Constitution, a simple matter of somebody telling a story that you were not supposed to do a check on a particular office got me removed from office. So, to our dear panelists, with all these constitutional provisions that are in place and others that are probably planned to be in place, what can be done to ensure that those who have to make the decisions, be it the president, be it a committee set up, are not influenced by whatsoever to make the wrong decisions? Because I didn't know that the ombudsman and the EC person here had actually been removed that way. I thought it had never happened before in Ghana. How do we stop this thing from happening? Because if it continues like this, we're not going to be having any independent institution. We're going to be having a situation wherein holders of these positions will just be doing the will of those that appoint them. And even if we're saying these positions, the people holding them have to be elected rather than appointed, if it is again a political thing, the independence will not be there. So how do we move from this point? It's good to have the laws and that, but when it comes to the practicality, it again becomes a subjective situation. Thank you.
Thank you very, very much. So we go back to our question. We go back to the panelists for their responses, and then we'll take our final set of questions, if any. So the first question had to do with the models in terms of democracy, the comment about the Swiss model, and whether there is academic appetite for it to consider when it comes to reforms. I'll start with Professor Prempeh.
Sorry. Yeah, sure. I think you know, when we think of democracy, especially in the Anglophone context, but probably also generally in the African context, our default models are understandably Anglo-American and maybe Anglo-Franco-American. Right? But I have been a strong advocate of this concept of varieties of democracy, right? There are all kinds of democracies, including, I mean, so if you want to limit yourself to just electoral democracies that respect rights and all of that, even that, there are all kinds of democracies. And I think we do ourselves a disservice when the default model that we look at and that tends to inform our conversations around democracy and institutions and all of this is especially in the Ghanaian context, the Anglo-American model. There are, you know, the continental European models, including the Swiss model, the Scandinavian and other models are there. They tend to be less conflictual. They tend to, you know, lean more towards consensus building, which in my view is probably, you know, more in sync with African, you know, communitarian values at the local level. They tend to give a lot more voice to communities at the local level and the like. So there are these different models that we unfortunately tend to gloss over when we are thinking about building institutions and democratic institutions and the like, and maybe just, you know, the long arm of the colonial inheritance continues to hold sway, and we defer only to these very divisive, in my view, highly polarizing models, especially the Anglo-American model in our case. So yes, I'm definitely very open and very interested in looking at different ways of answering a particular question. For me, a constitutional design is a problem-solving enterprise. You have a problem with social, political, economic organization. You are looking for different ways of solving them that are sensitive to the context. And so however, you know, whichever models, whichever case studies, whichever ways of answering the question are available and appeal to you and can do the work, I mean, I'm all in favor of it. I'm not particularly tied to, you know, a particular model. So in this conversation, for example, I'm giving the example of the Constitution Review Committee. Ghana has never, as a country, elected a mayor at the local level. From the colonial period to this point, it was the governor who was picking. The district commissioner, since independent, is the president who picks. So that is how we have governed local communities. It's a very paternalistic model. It tells the local communities, you guys are not smart enough to make decisions about who to do your own budgets and to determine things for the district and the community. We want to move away from it. It's most likely one of the reforms that come out of this process is that we're going to change that. How are we going to do it? There are many different models of doing it, right? And we are canvassing various comparative options. We're also looking at, our own traditional chieftaincy institutions. How do you mainstream them, at least at the local government level, so that you don't throw away the organic legitimacy they have with the people? It's a very important resource. People defer to chiefs, but there are other concerns around chiefly power, and therefore, if you are going to give it to bring back the chiefs into a local governance system, how do you moderate, how do you regulate, how do you balance these things? So for me, I'm very open to looking at these different ways of solving a particular problem of social organization. And it's not for me about a model. And the Swiss actually, among the things we've looked at, because they do a lot of local democracy, well, sure, it's one of the things that the readings that we're looking at. So it's not entirely out of the question. The question about how do we, and especially I think in Ghana, we recognize that. Going back to the same old last question, we recognize that this is a resource that we need to find a way to use. Unfortunately, we've been very binary in our decision-making around these things historically. So at the dawn of independence, at the end of the decolonization period, it was a question of, do the colonial authorities, departing colonial authorities, hand over power to Kwame Nkrumah and his modernizing elites, or do we hand over power to the chiefs, as if it was a binary decision? And unfortunately, we've carried on with this binary way of looking at things. Why couldn't it have been a mix of both? Why couldn't we have some where the chiefs are able to do, for example, on issues of conservation, protection of environment? Historically, chiefs have done very well there. We are faced now with a problem of ecocide, illegal mining and all of that. The central government clearly seems out of depths. Out of its depths. It just can't solve the problem. Can't sit in Accra and allocate mining rights to communities that are most proximate to the mine. They don't have a say-so in how you do it. They don't have a share of the benefit, and you expect that they will just look on and not take the mine, take the mineral. So something needs to give, right? And the chiefs usually are there. They can do some work. They can do something. You just can't use them as tourist decoration, and then people come and then there are festivals and then they're wearing their flowery clothing and stuff like that. There is a function they can perform. So I think, at this stage, we are at a point in our history where we've seen that certain things have not worked. How do we redo it so that we can make the most of the resource, homegrown resource that we have? And the chiefs are now also very highly educated. Really. When we've done our rounds, they're extremely educated and they cannot see why. The one thing that disqualified them in the past was this idea that they were not Western educated. And now many of them, the average one, is better educated than the people we have in our parliament. So really, what's the point? Right? So they're like, look, you're not better than we are. And meanwhile, you have also messed up, quite grotesquely in some cases. You really mismanaged this place. So what gives you this, because you were voted for in an election? We have organic legitimacy too. It's time immemorial. So there is this new contest for power. And I think, some of these questions may be resolved in this process to our benefit if it works that way. Yes, I do think that, the problem that we face, unfortunately, because we have had this prior experience of the same Article 146 being used to take out other independent constitutional office holders. That has become an unfortunate precedent, right? Because those steps have already happened, and it did not raise a lot of eyebrows from the larger society. We at Civil Society, CDD, I remember that, and again, appointments and removals are related in this way. If you have a constitution that says when there's a vacancy in the office of Electoral Commission, that the president just gets up and announces that I have appointed 3 new, this is the captain of one of the 2 main teams in your World Cup matches that you play every 4 years. And the captain of the team gets up and says, I have appointed these referee and 2 linesmen for the next game. Nobody, no other person has an input in the process, right? And so when you have that on the front end, and you come and meet somebody you didn't appoint, there is an incentive for you to want to vacate that office so that you can replace them. So if the appointment process on the front end was more difficult, if you didn't control it by yourself, it was multi-layered, there were more parties involved, then you would know that at least even if you manage to remove them, you're not going to have it easy replacing those with your own appointees. So that's one way. So this is a way in which the front-end appointment process and the back-end removal are related. But clearly, we can't have this kind of a system where just because you come to meet somebody you didn't appoint, that you mistrust that person instinctively, and therefore you must initiate processes to remove them. We had to go to court in the Supreme Court to fight against the removal of our Auditor General. We succeeded, but only after he had left office. We filed the case, I think, sometime in 2020. The decision didn't come down into 2022. And when you do that, the public will look at you and say, well, the Supreme Court just found a very clever way to basically not address the question. How did we win 7-0 when it took 2 years, to come up with a decision like that? So the courts, again, people look at you and they make judgments about the way you are behaving and the way you're exercising your power. And they say, look, this is not acceptable. And the court must take those critiques on board fairly and say that you cannot just be playing what appears to people as politics with your power and expect that when you come under attack, then everybody will rally to your defense. So I think it's important for the courts to take on board the critique and not to pretend that they are saintly and self-righteous and that somehow we should all accept that the judiciary is sacrosanct. Well, make it look sacrosanct. If it is sacrosanct, then you should use your power responsibly, and then people will see the game that's being played against you, and they will all be up in arms when somebody wants to play tricks with your power. But don't look like you are yourselves abusing power, playing to the political class, and then when the wind turns, then all of a sudden you are looking for allies. It is not to say that one shouldn't stand on principle, to say that you don't cross certain red lines, because once you cross them, it will be used in the next case. So yes, I think we should be mindful of those things. Should the president be removed from the process? Absolutely. I think going forward, it's not healthy, right? It is a temptation. You don't tempt power in these parts like that. Certain things we have done with our constitution almost presume that the people we are going to elect are angels. I mean, it is one of the most ridiculous. Our constitution is too permissive. It trusts power holders too much. Whether they are the president, they are the chief justice, we trust people with power too much. So there are almost no restraints on anybody with power in this place. And whenever you say the president shall do this, the president in Ghana, I mean, shall sometimes, in some places, shall is a duty. Right? So in Kenya, the president appoints the judges. But it is understood as a duty to appoint once the Judicial Service Commission has nominated them after going through an interviewing process and they've come up with a list. You just have a duty to take it to Parliament for them to approve. And once they approve, you have a duty to appoint. In Ghana, you say shall. Hey, that's my power. It is, I shall appoint you. So I do the thing by myself. Absolutely, the president shouldn't be given that kind of power. Whether on the appointment side, or on the removal side. I don't see the point, right? I mean, and then you have other things like the sitting justices on the Supreme Court, your peers. must now sit in judgment upon you in an in-camera proceeding. Why do you think the Kenyans, when they got there, said no? Go for retired jurist. They know, they've experienced these things before. So the Kenyans, the same removal provision in another common law country. So no, when it gets to that point, go and borrow some retired judge. Or if you can't find any, actually go to the Commonwealth countries and find one. Find one or two or three. It's in their constitution. Very Pan-Africanist. They allow, they say you should go to the Commonwealth Africa and go to Ghana and bring somebody to come and sit in judgment on this case because this person's peers on the same court. We don't, even if they will do justice, we don't want the collegiality and everything to be wrecked. So leave them out of this. But you've written a flawed constitution like that, and then now that is being applied, we are all up in arms. Why is it in camera? Why must justice be done in camera? Right? I mean, so I don't understand the point of it. It's a national security issue. Initially, they said it was for the protection of the institutions so that they are not washing their dirty linens in public. But this kind of a person doesn't help anybody. So when this matter came, my first comment on it was, look, even if it's in camera, if the proceeding itself is in camera, we must at least be open to everything being published after the fact. Because I can't change the constitution at that point, right? I cannot read the constitution and say that this is just best practice. It's not in the text. I don't think that is a proper reading of the constitution. It is there that it must be in camera. So for now, it's in camera. But why can't we at least agree that after the fact, the in-camera clause or provision or text does not stop us from publishing, the judgment. Maybe not the proceedings because it would defeat the in-camera idea, but at least the judgment and the reasoning. Okay. Nothing like that is in the Constitution. It's not required. Nobody says we should publish anything, right? So I think, it's a bad situation. I mean, I'm not particularly sure there is a whole lot we can do about it. But I think going forward, we must fix it. There is no reason why we should have a system like that. Because when people come here and they are surprised that our electoral commission is choosing the way it's choosing, and we still trust election results. This would never, many places, they would never accept it. That the president can just pick any 3 people to constitute the commission, or 3 or 4 or 5, and the other people accept the results as fair.
Okay. So the questions, 3 questions have been addressed so far on the appetite with respect to considering the Swiss model, academia considering the Swiss model for reforms, and also the removal process. I'll come back to Professor Prempeh because I don't think that the issue on practicality has been addressed yet. So that the practicality of making sure that there is accountability, but also that there is real independence, so that we don't run the risk of knowing that the only way I can really secure my position is to make sure that I am in the good books of whoever is in government, and then to act accordingly. Because yes, you see the law, but if you're smart enough and you understand the terrain enough, you also know how it can be gone around. So if you are being realistic, your only way to securing your post is making sure that you are in the good books of the one who has power. Professor Tin, I come to you with respect to the question on social justice and then the fear of retribution. What do you think would be best for judges to do? In a military regime, for example, judges have the duty to uphold people's rights, but what's also about what happens to them after the judgment, and also even when probably there are issues of transition. Of course, the soldiers are also interested in their survival and their safety afterwards. What do you think can be done or judges can do?
Bon, j'aimerais quand même intervenir un peu sur la question de la démocratie directe en Suisse. Parce que ça a commencé à Athènes d'abord, sous Périclès, 4e, 5e siècle. Mais il faut dire qu'en réalité, il y avait quand même à peu près 700 000 maximum la population. Et c'est intéressant parce que l'idéal de la démocratie, c'est l'égalité. À Athènes, il faisait le tirage au sort. Le principe d'égalité faisait que les gens pratiquaient le tirage au sort beaucoup plus que le vote. Même après 1789, vouloir dire je suis candidat, c'était une prétention. Peut-être se sentir plus supérieur aux autres. Mais il est évident que la démocratie directe de nos jours, c'est extrêmement difficile. En Suisse, c'est quand même une petite fédération. Je pense que 50% des référendums dans le monde, ça se pratique en Suisse. C'est en réalité donner la parole au peuple, aux citoyens, retourner la souveraineté du peuple au peuple en réalité. Je pense que le véritable régime populiste dans le sens, je pense, le plus positif du terme, c'est ce qui se passe aujourd'hui en Suisse. Et peut-être maintenant, comment réintégrer le peuple? C'est-à-dire un horizon de progrès dans la démocratie, c'est d'abord par l'indépendance de la justice, mais également, c'est le fait de voir quelles sont les modalités d'intégration du citoyen dans le jeu, comment les impliquer dans le jeu politique de façon globale. Je viens maintenant sur la question de la justice, surtout dans les pays qui sont en crise, parce que j'ai fait quand même l'expérience directe de la question de l'impunité au Mali. Avec d'abord, en me réunissant avec les militaires, c'était le grand problème, le nœud du problème qui revenait souvent en matière de droits humains, c'était la question de l'impunité. Discuter avec la justice militaire, avec le ministre de la Justice, ils ont pris toutes les résolutions possibles pour aller de l'avant au Mali. Ça, je vous le dis en tant qu'expert indépendant. Mais l'impuissance à justement régler la question de l'impunité parmi les militaires était totale. Pour une raison simple. Dans ce pays, il n'y avait que les militaires comme institution. Et ils ont les armes. Et il ne fallait pas, comme on dit, démoraliser par le risque de juger des militaires qui sont au front. Je pense que ça faisait un problème avec la justice militaire. Il y avait toute forme d'aide donnée par l'Union européenne, mais ça ne marchait pas. Il y avait toutes sortes d'experts sur place, mais ça ne marche pas. Deuxième problème, quand il y a des problèmes d'insécurité, le responsable, j'ai tout joué, le juge chargé de la lutte contre, comme on dit, comment on appelle ça encore, j'oublie le nom, le terrorisme, voilà, qui avait tous les pouvoirs. Et dans son bureau, il m'a avoué son impuissance. C'est-à-dire quand tu vas traquer quelqu'un qui se trouve dans une région qui est en conflit, tu n'as même pas les moyens de t'y rendre. Premièrement, les moyens. Généralement, c'est la MINUSMA, quand la MINUSMA était sur place, qui arrivait jusqu'à la frontière pour dire, écoutez, nous, notre compétence, ça s'arrête là. Débrouillez-vous. Et il m'a dit, qu'est-ce que vous pouvez faire? Et maintenant, la question de l'impunité et des résolutions qui sont faites, les résolutions sont faites sur la base des rapports sur les droits humains que l'on faisait. Quand c'est déposé par la France, vous avez le veto de la Russie et le veto également de la Chine. Donc, aujourd'hui, la question des droits humains et des violations des droits humains qui sont graves au Burkina, qui sont graves au Mali, qui sont graves, l'impunité est pratiquement totale. Parce que les superpuissances qui aujourd'hui mènent une espèce, si vous voulez, de guerre d'influence au sein de la CEDEAO, c'est comme ça aussi qu'ils ont cassé la CEDEAO, hein, qui est devenue... La CEDEAO, ce n'est pas seulement la CEDEAO, hein, ce n'est pas seulement les pays. Il y a une guerre d'influence qui a abouti à la scission de la CEDEAO. Donc, on ne peut pas seulement traiter de la question de l'indépendance des juges et de ces questions sans considérer le contexte global, le contexte politique, le contexte de conflit. Tout cela, ça joue sur les capacités du juge à agir ou à ne pas agir. C'est ça que je voulais dire. Maintenant, qu'est-ce qu'il faut faire? Parce que nous sommes dans un contexte tout à fait spécial hein, à l'heure actuelle, avec le retour des populismes. C'est un retour extrêmement puissant. C'est la chute du mur de Berlin des années 90 qui avait créé un contexte global de démocratisation, de liberté, de respect des libertés et de respect de la démocratie et du pluralisme en Afrique. Aujourd'hui, c'est un retour en arrière. Et ça fragilise même la communauté de façon globale. Parce que vous avez un pays comme le Togo, voilà, qui ne respecte, qui fait des coups d'État inconstitutionnels, mais la CEDEAO n'ose même pas agir. Il y a des violations des droits de l'homme parce que aussi la Commission des droits de l'homme de la CEDEAO a aussi une compétence pour agir sur la question des droits de l'homme. Elle n'agit pas totalement. En Côte d'Ivoire, tout le monde sait qu'aujourd'hui, la crise, elle est là. Les risques sont là si certains candidats sont exclus, mais la CEDEAO est totalement impuissante. Donc, nous sommes, de mon point de vue, aujourd'hui, aussi bien au plan politique, démocratique et social. L'autre problème, effectivement, pour améliorer la démocratie de façon globale, c'est la consolidation de l'État social. Je reviens sur l'État social. L'État social s'est effondré pratiquement dans notre sous-région. Et l'effondrement de l'État social est la source profonde des conflits que nous avons dans la sous-région. Il me semble qu'en matière de justice, la justice sociale doit s'exercer. Les droits économiques, sociaux et culturels, nous devons les respecter de plus en plus. De toute façon, ça ne compte pas. Les responsabilités, d'abord, moi, travaillant sur les droits humains, on travaille sur les droits civils et politiques, mais quand même, on oublie les droits économiques, sociaux et culturels qui, non seulement fragilisent les populations, elles fragilisent les institutions, elles fragilisent aussi la démocratie, y compris, effectivement, les juges. Maintenant, je reviens sur une question que vous avez soulevée sur le Sénégal aussi, et qui me semble important hein, dans ce qui se passe sur le plan politique et sur le plan même de la justice. Dans notre tradition orale, il y a ce qu'on appelle le Kumba Amnei et Kumba Amulnei. Vous savez, dans les contes, c'est le Kumba qui a une mère et Kumba qui est l'orpheline, et qui est éduquée par sa marâtre, donc qui lui fait toutes les souffrances, et à la fin, elle va se marier avec le prince. Et Kumba Amulnei, c'est ça ce qu'on appelle la justice du Kumba Amulnei. Le Wolof dit, tu caches ton propre fils et tu frappes le fils de l'autre. Et aujourd'hui aussi, ce qui a fait que ça passe, c'est que le débat politique se passe dans les langues nationales. Beaucoup plus. Le débat juridique se passe aussi dans les langues nationales. Quand le procureur fait sa conférence de presse en français, il le fait aussi en Wolof. Et ça aussi, ça permet de développer une conscience de son droit et une conscience, si vous voulez, de sa citoyenneté et de son implication. Dernier point sur lequel je voudrais m'adresser et que les gens ne considèrent pas, c'est le développement exponentiel de l'espace public avec les réseaux sociaux. Que d'ailleurs, les autorités publiques ne peuvent pas, si vous voulez, contrôler. Mais aujourd'hui, contente avec les crises, hein, dès que ça commence, on coupe Facebook, on coupe Twitter. Il me semble que cette question aussi doit être prise en contact par nous. Mais en même temps, il y a des limites, parce que les limites, c'est des limites nationales. Parce qu'à l'extérieur, quand même, les gens peuvent s'exprimer. Et le fait, effectivement, qu'on a cette ouverture de l'espace public donne la possibilité aussi de mettre la pression pour avoir une justice indépendante et améliorer aussi la démocratie. Parce que la démocratie est en train de s'améliorer dans ce sens avec les réseaux sociaux qui peuvent être, comme on dit, hein, comme disent les Grecs, qui peuvent être un remède, mais comme qui peuvent être aussi un poison. Et les deux fonctionnent maintenant. Comment réguler? Il me semble que ça aussi, ça fait partie des questions que nous devions adresser.
for that. Professor Mempe, I don't know if you want to have a take on the issue about the fear of retribution and just what judges can do in 1 minute.
What kind of retribution? Sure, I think once we have sufficient protections in place, the idea, of course, there has to be, there's one aspect of this conversation we cannot script, which is judicial integrity. I mean, it's basically, maybe you can treat it as an occupational hazard. Yes, once you are a judge sitting in a particular role, not just the politicians, almost every party to a case wants to bend you to their side. The litigants before you, if they could procure a favorable judgment through some underhanded means, they would use it too, right? So while we tend to talk about judicial independence and we're looking only as the the actors as just the judges and the political actors, other influences are there. Your church, your pastor, your mosque, everybody wants to have, you make a decision that favors their interest, right? So there's the big question of judicial integrity and impartiality that comes with a job. That one, I don't know that any constitutional or statutory provision can help with that. If it's there, if it's not there, it's not there. So there's a limit to how much we can talk about these. But I do think that judges must not make themselves into these tin gods that nobody can talk about. It doesn't help them. I do think that it's important to cultivate a constituency of support, both within the judiciary, not just that you band together, some kind of a secret code, but it is important. In Malawi, when the president wanted to go after the Chief Justice, when the first election results were declared against him, or the court ruled against him, it was the judges themselves, the Magistrates Association and the other, who said, no, we are not going to accept this go on leave order that you have imposed on the Chief Justice. So you need your peers to be with you, but you also need larger society to be with you. More transparency helps. If the public see that you're doing your best with the power you have, you are doing justice, and the political class want to come after you, they will support you. They will push back. Because if you are not elected, you have to cultivate allies from within the public. That's the way you actually shield yourself against those who are counting on their electoral base to push you out. Fear of retribution, it would come from many places. They would design all kinds of ways, but that is why we need to make it difficult in the text. We need to make it difficult for you to be removed that way. And if you have shown fidelity to the text in your work as a judge, then, once we have very strong text protecting you, then we can be sure that it will work. But if you don't trust the text, then somebody else will come and say, oh, but here, you can use any text, you can interpret it anyway. So I really, this issue of fidelity to the text, not that I'm some literalist, but the text it matters. That's why we put it there. That's what we adopted as the Constitution. That's what we went to a referendum to approve. We didn't approve some subjective thinking in some judge's mind that we didn't know. We approved a text. If there's a problem with the text, it can be amended. Of course, every now and then the text doesn't answer the question. Then you can explore. Then you can use other structural, historical arguments, purposive. All of those things are still there. Those tools are there to interpret the text. But this idea that a judge is not constrained by the text and they can do whatever, if you start going that way, the politicians they will envy your power and they'll come after it, because then you are the law unto yourself. So I don't think that once we do the right protections, we should worry about retribution. But judges must know that they must cultivate public support. And the only way you do it is through transparency, through being open to criticism, attending judicial, academic conferences, letting the academics critique you. After all, the Constitution says you can change your mind, right? The Constitution says in the text, the Supreme Court can change its mind about a case and come up with a different decision in the future. If you can change your mind, then obviously it means that you can get it wrong. and somebody can critique you. But if you don't want to be critiqued, but you just want to issue orders for people to obey you, sheepishly, I mean, that's not going to happen. So I don't worry about retribution as such. I think the design flaws must be solved. Once we solve these design flaws that make it too easy to appoint, too easy to remove, then judges should feel safe that they can do the work. But they must cultivate a constituency of support from civil society, from within the public. And it comes with being open to being held accountable intellectually, not in any other way. Nobody's going to elect judges here. It's gotten so bad that now in Mexico, they have changed their constitution to elect judges. Because if it gets to a point where people think that, but you are just another politician in black robes, then they will say, why don't we elect you then? Then let's elect everybody. If you are just another politician making decisions, then let's elect everybody. But people must trust that you are not a politician, that you are following a craft. There is a profession. There are rules about how you make decisions. There are certain ways you go about making and reading a text and applying it to solve cases. But if they don't believe that that's what you're doing, then why the bother?
Okay. Thank you very much. I'm sure you agree that we've had a very, very of the themes that have come through is that include that we have to balance judicial independence with judicial accountability. The issue about academia, I'm a lecturer. There are some of my colleagues who would tell me that they will never come into the public to say anything unless they are going to praise the judges, particularly those who have active practice careers. They have their cases in court. If they come out and then they criticize any judgment, when they go to court, move your motion dismissed, objection overruled, motion dismissed. At the end of the day, they will lose their cases. What does that mean? Their clients will take the hit because they want to contribute to the discussion. So the issues of judicial independence, balancing it with judicial accountability, also with respect to access to justice, to see how we can improve access to justice and how we can do this using traditional justice as well. The issues about perceptions and corruption. There are two phrases, judicial phrases. We always say that justice denied. Justice delayed is justice denied. Then using it politically, you come and say, oh, justice hurried is justice buried. So a case that goes to court, then you take 2 years on a simple matter, really. On a very simple matter. Then it takes 2 years after the fact to come back and say that, oh, yes, it shouldn't have happened. But it happened 2 years ago. Even though the case went. So when that happens, as noted, the public can also see this, so they can realize that, oh, okay, so we just actually have another bunch of politicians, just that these ones are in wigs, as we would say. Then there are the issues, of course, the questions that have come and the responses that have come in. But ultimately, we also have to think about how we can improve our democracy and look at other forms, apart from the ones we are very familiar with. We may also want to consider from other models like the Swiss model as well. And basically, if we are talking about independent institutions, we just don't leave certain letters in legislation or the constitution that really do not guarantee the independence. So we have to also look at the practicality of how to ensure that. We've been sitting for quite a long time, so I'm sure it's time for us to take coffee break, and then we'll reconvene after 15 minutes. So please, this is time for a coffee break. We'll come back after 15 minutes. Thank you.